Thank you everyone for joining us. The webinar will begin just around 12 o'clock. We're waiting for a few more people to join. So sit tight and thank you. Hi everyone, thank you for joining us. The webinar will start in just a few minutes. We're waiting for some more people to trickle in, so sit tight. We'll start promptly at noon.
Hi, everyone. Welcome to our lunchtime webinar, where, as you know, we're going to walk through the new Massachusetts Equal Pay Act. I first want to start by thanking you for spending your lunch hour with me. I promise to make it worth your while. I'd also like to start by briefly introducing myself. For those of you who don't already know me, my name's Allison Belanger. I'm a litigation associate here at Krokidas Bluestein, and I primarily practice in the school law, healthcare law, and employment law areas. While I'm doing introductions, I'd also like to tell you a little bit about Krokidas and Bluestein as a firm. Our focus today is employment law, but we actually consider ourselves a full-service firm for our clients. We represent clients on a variety of matters, including school law, healthcare law, corporate governance, nonprofit law, state ethics, contracting, public procurement, real estate, finance, and of course, labor and employment matters. So as you might guess, in our employment law practice area, we often help our clients prevent and occasionally respond to claims of discrimination, which brings us to why we're here today. The new Massachusetts Equal Pay Act makes it unlawful to discriminate in the payment of wages on the basis of gender. So we'll spend our time today unpacking that, but before we really dive in, I want to share a couple of quick notes about the webinar process. You'll see a questions box on your screen. If you have any questions at any point during the presentation, just put them in that box. I won't address them until the end, but feel free to submit them as they come to mind. And then in the coming week or so, we will post a copy of these slides on our website, and we'll also post a recording of the webinar. You'll also get an email when those materials are available for you. So I'd first like to start by walking through a bit of the history of the equal pay movement, because the historical context is really helpful for understanding the what and why of the current law, which is why we're here today. You've probably heard the term equal pay for equal work before. In fact, this concept originated as early as World War I, when women started to step into the jobs of men who were deployed. And even though it arose so early, decades actually went by before it was addressed at a legislative level. It really wasn't until World War II when this really started to gain traction. At that point, Representative Winifred Stanley introduced the first federal Equal Pay Act. The first federal Equal Pay Bill. It didn't actually go through, but at the same time, around the same time in 1945, Massachusetts did pass its own Equal Pay Act, and it became the first state in the country to do so. That 1945 law prohibited employers from paying women differently for work of comparable character or work on comparable operations than men. So you might notice that this is a bit more generous in the equal pay for equal work concept. It not only prohibits variations in pay for equal work, but comparable work, which is a broader category. The word comparable was actually a bit controversial. 2 years after the first law was passed, it was revised to strike the word comparable and instead prohibit variations in pay for work of substantially the same character. This 1947 revision also introduced a bunch of exceptions to that rule, permitting variations in pay based on things like seniority. The problem with the 1947 law was that it also included a very broad exception. It allowed variations in pay based on any reasonable differentiation other than sex. So because of that, the law didn't really have any teeth. So 3 years later, it was revised again, given a few more teeth. The exceptions were all struck, except for it kept the seniority exception, and the term the term substantially the same was reverted back to comparable. Aside from a 1980 revision that made the law gender neutral, the 1951 version of the law is the one we lived with up until just last summer. In the meantime, the federal government did pass its own Equal Pay Act, which is narrower than the Massachusetts one, prohibiting only variations in pay for equal work. So despite the age of the law and its pretty active legislative history, at least initially, there was very little enforcement of the law. I was only able to find it first published in litigation materials in 1978, and then only after that it was very infrequent. So the lack of enforcement rendered it pretty ineffective, and in 2018, women were still only making 84 cents for every dollar men made. So in 2016, the Massachusetts legislature revisited it and ultimately passed the new Massachusetts Equal Pay Act, which became effective on July 1st, 2018. So to get to the meat of it, you'll see on your screen the actual language of the law. You'll see that the new law makes it unlawful for an employer to pay an employee of one gender differently than the employer pays an employee of the other gender for comparable work. It sounds very familiar. It sounds like what we talked about, the law said in 1945, but there are a few distinct differences. One of the big differences I see is that the Attorney General has expressed a lot of interest in enforcing this. The AG has been pretty active in issuing guidance on this, which signifies that it's going to see a lot more enforcement activity than the old law did. The new law is also that we finally have some guidance on what comparable work means, which is we'll spend a lot of time today walking through. And finally, and I'll go into these later, I won't go into them right now, the law does a little bit more than just make it unlawful to pay people differently for comparable work, and we'll talk about those later. So for now, I want to unpack what comparable work means. It's one of those complicated terms that in order to understand, you need to interpret definitions within definitions within definitions. So we'll walk through it together. Comparable work is work that is substantially similar in that it requires substantially similar skill, effort, and responsibility, and is performed under similar working conditions. So first, I want you to notice all of the ands in this definition. In order for two positions to be considered comparable, all of these elements have to be satisfied. So first, you have to understand what substantially similar means. Substantially similar means alike to a great or significant extent. This does not mean that the element that you're interpreting has to be identical or alike in all respects. Minor differences will not prevent two jobs from being comparable. Second, when you're interpreting whether work requires substantially similar skills, you should be looking at factors such as experience, training, education, and ability to perform required to perform the job. You have to measure this only in the skills that are actually required to perform the job, not just skills that an employee happens to have. And I'll give you an example later as we later that gives you a little bit more detail about that. Third, in order to be substantially similar, the work has to require a substantially similar amount of effort. This one sounds like an obvious one, but effort is the amount of physical or mental exertion required to perform the job. And in order to be substantially similar, the work also must require a substantially similar degree of responsibility. Responsibility means the amount of discretion an employee must exercise to perform the job, the accountability associated with performing the job, the duties that the employee regularly performs, how much supervision the employee receives, or conversely, whether the employee is responsible for supervising others, and whether the employee is involved in any decision making. And then finally, in order to be considered substantially similar, work has to be performed under similar working conditions. Working conditions are things like physical surroundings and hazards associated with the job. For example, if one job requires an employee to perform work outside in the heat of the summer, it is not performed under similar working conditions to a position where the employee works inside in an air-conditioned office. This working conditions element also takes into account shift differentials. So an employee who works the night shift performs the work under different working conditions than an employee who works a day shift. So what this law is going to require you to do is go through each and every one of your positions and group them based on comparability. So then within each group, you can identify pay disparities between genders. Grouping the positions is going to be the hardest part. You'll have to carefully walk through this definition, just like we did. And for each and every position, like I said, which is why understanding each element is really important. So let's go through some examples to make you more comfortable with doing that. I will say, the small disclaimer, in coming up with these examples, I looked at job postings through databases like Indeed.com. That said, you have to know that looking at a job title and looking at job descriptions is not going to be enough to evaluate comparability. You must really review what each employee actually does in his or her day-to-day experience. That said, this is a really good time to remind you that it is helpful to have updated and accurate job descriptions. So you should really take the time to regularly update them and make sure they match with what each employee is actually doing. Again, you can't analyze comparability based solely on job descriptions, but having accurate ones is helpful because it will help you identify which positions are going to require a really close analysis. So let's compare these two positions, a custodian and a cafeteria worker. Now on their face, they're nothing alike. The duties of a custodian are totally different than the duties of a cafeteria worker. But think about the definition of comparable work that we just went through. There is no requirement that the duties be the same or similar. Rather, we look at whether the two jobs require substantially similar work, substantially similar skill, effort, responsibility, and are performed under similar working conditions. In this particular case, I would say that a custodian and a cafeteria worker probably require substantially similar skill in that they both require little to no education or experience, and training is probably the same or none. But remember, again, like I said before, the analysis here is whether the two jobs actually require the same types of skills. It's not whether somebody happens to have additional skills. So if you have a custodian who has a PhD in philosophy, that doesn't render the two jobs non-comparable because that PhD in philosophy is not a required skill for that position. I would also probably say that these two jobs require substantially similar effort. Both likely require the individuals in those positions to exert a high amount of physical energy. For example, a custodian probably has to lift heavy equipment, take trash out, and a cafeteria worker probably has to lift boxes of food, unload food boxes, and maybe use heavy kitchen equipment. I would also probably say that these two positions require a substantially similar level of responsibility. I don't think a custodian or a cafeteria worker are necessarily entrusted with a high degree of discretion, and they are both heavily supervised. But keep in mind, this would change if we were talking about someone like a maintenance director who is responsible for supervising other employees. Finally, assuming the custodian works a day shift and the cafeteria worker works a day shift, I would say that these two jobs are performed under similar working conditions. But if the custodian works the night shift and a cafeteria works the day shift, the two jobs would not be comparable because they're not performed under similar working conditions. So putting that all together, assuming that they're both working the same day or night shifts, it's likely that these two jobs would be considered comparable and you have to pay them the same. So the next example I think would be helpful to walk through is an HR director versus an executive assistant. Again, remember, you look at whether these two positions require substantially similar skill, effort, responsibility, and are performed under similar working conditions. Rather than go through this one in as much detail as we did the last example, I just want to point out what I see as the major differences here. First, the two jobs require different levels of experience or skill. The HR director, I would imagine that employers want to see a lot of experience, whereas executive assistants, they likely require less or no experience. Second, and here's where it's a good example of why you have to look at what these employees actually do in their day-to-day work. I think these two types of positions probably exert different degrees of effort. An HR director probably uses a high degree of mental exertion, and an executive assistant might, but it might be a little bit lower than the effort the HR director has to exert. But again, you have to be looking at what these people actually do every day in order to properly evaluate that. Third, these two individuals clearly have differing levels of responsibility. An HR director exercises a lot of discretion. He or she's responsible for employee discipline. He or she's responsible for creating, revising, reviewing policies. And he or she probably supervises individuals in the workforce. An executive assistant, by contrast, is heavily supervised and exercise little to no discretion. So because there are so many differences here, I think it's safe to say that these two positions are not comparable. And an employer could pay, for instance, a female HR director more than the employer pays a male executive assistant. So I want to bring us back to the reason why we're thinking about this, to put it into the context again. If you remember, the new law makes it unlawful to discriminate on the basis of gender in the payment of wages for comparable work. So that's why we spent so much time really unpacking what comparable work meant. But now we have to unpack what wages means. This one's a bit easier. It just means forms of remuneration, but it's not just salary. You have to be thinking kind of creatively and thinking very broadly here. It includes bonuses, profit sharing plans, and other types of incentive payments, paid time off, car allowances, and benefits like that. One thing you should know, that you need to know, is you can't lower one employee's wages in order to equalize it to ensure compliance with this law. Doing that would violate this law. You have to bump the lower person up to equalize it. You also have to keep in mind that you can't make up lower wages with larger benefits in order to equalize them. The ratios have to be similar. So if one employee has a low salary but a lot of benefits, and another employee who's performing comparable work has a high salary with few benefits, those are not considered the same wages. You have to make them equal ratios. So by now you're probably thinking that this is wildly restrictive, and if we were to stop there, I would say that you're right. But luckily, there are some exceptions that permit an employer to vary pay for comparable work. Before we go through each item on the list, keep in mind that this list is exhaustive. This is not one of those including but not limited to lists. If the reason you are paying an employee differently than you're paying an employee who's performing comparable work is not on this list, it is unlawful. So first, you see that the term system appears several times in this list. So let's go over what system really is. A system is a plan, policy, or practice that is predetermined or predefined. It's used by managers or others to make compensation decisions, and it's uniformly applied in good faith without regard to gender. So this has to be something that's already existing. You can't just make up a, quote, system when you want to pay someone differently on the fly. So now to get into the exceptions, the first one is seniority. You're allowed to pay employees differently for comparable work if it's based on a system, if the variation in pay is based on a system that rewards seniority. I think that one's pretty self-explanatory, but remember that you can't reduce an employee's seniority for time spent on protected leave, like family or medical or parental leave. You can also pay employees differently even if they're performing comparable work, if it's based on a merit system. Merit system, again, might be obvious. It's a system that pays employees based on their performance. But keep in mind that their performance has to be measured through legitimate job-related criteria. And you should also be really careful to document your evaluation of employees' performance if you're going to rely on this exception. So for that reason, you should consider conducting regular, periodic employee performance reviews. One note of caution. We often see cases where an employer comes to us and wants to, for example, terminate an employee's employment based on poor performance, but we look for performance reviews and either they don't exist or they were all average or above average. Documentation is key. If you're going to base an employment action, so a raise or termination, on performance, it has to be documented. And so, be sure that you're documenting criticisms too. I know criticism is hard to deliver, but there's a way to do it professionally, and you shouldn't be shy about doing so. It's important if you're going to rely on an exception like this. You're also allowed to pay employees differently even if they're performing comparable work, if the variation in pay is based off of a system that measures earnings by quantity or quality of production, sales, or revenue. So this one, again, is an obvious one. If an employee works fewer hours than another employee, you can pay that employee less. You're also allowed to pay employees differently for comparable work if the variation in pay is based on their geographic location. So you can pay an employee who works in a city like Boston more than you pay an employee who works in a city that has a lower cost of living. And you're also allowed to pay employees for performing comparable work differently if that variation in pay is based on an employee's education, training, or experience, but only if that education, training, or experience is actually related to the particular job in question. It's considered related to the job in question if that training, skill, or experience would help them perform the job more efficiently or more effectively. So if you remember the example from earlier, the custodian with the PhD in philosophy, that likely does not justify using this exception because a PhD in philosophy is not at all related to a custodian position. So you couldn't pay the custodian more than you pay a cafeteria worker just because the custodian has this irrelevant degree. So finally, you're also allowed to pay employees differently, even if they're performing comparable work, if one of them, as a requirement of their job, has to travel. An important point here, though, is you can't use this exception if the employee has the option of not traveling. It actually has to be a necessary and required part of his or her job in order to justify using this exception. So we've gone through all the exceptions, but before we move on, I want to point out one that is not on this list. And if you recall, I said if it's not on this list, you can't use it to justify a variation in pay, and that's supply and demand. I've heard this a lot since this law came out. People are concerned about incentivizing people to apply for positions when the applicant pool is smaller. I know that's the case, and I know it's hard with a lot of positions, but unfortunately, that's not a reason to pay someone more than you're paying another person performing comparable work. So I also mentioned earlier that this law does a little bit more than just make it unlawful for an employer to pay one employee more or less than it pays another employee. And here's that list. First, it increases the statute of limitations from 1 to 3 years. So the old law had a 1-year statute of limitations, meaning that an employee could only bring an Equal Pay Act claim if the employee raised it within 1 year of the alleged violation occurring. Now an employer can wait up to 3 years before bringing a claim. The new law also eliminates the requirement that an employee go to the Massachusetts Commission Against Discrimination before going to court. So under the old law, an employee had to go to the MCAD first before going to court, or a court would dismiss the claim. Now an employee can go straight to court rather than going through this administrative process. Third, and this is really important, the new law explicitly prohibits employers from limiting employees' ability to discuss their wages with others. Now, the National Labor Relations Act already kind of did the same thing, but now it's explicitly clear under Massachusetts law that that is the case. That said, if you have an employee who has access to other employees' wage information, you can still prohibit them from talking about those other employees' wages with others. So fourth and finally, it also prohibits employers from seeking wage or salary history before making a formal offer of employment. This one is probably the easiest one that you can practically fix. You can look at your applications and remove inquiries regarding wage and salary history. You can review your interview materials, so like interview scripts that supervisor used to remove inquiries. You can review reference check materials, reference check scripts don't include inquiries regarding wage and salary history, and training materials. You should review your training materials so that supervisors are trained on this prohibition, so they know not to be seeking this information. All right, so there's also one other big thing that this new law does. It creates this concept of a self-evaluation. So as a next step, you really should consider conducting a self-evaluation of all of your positions, meaning you go through each and every one of your positions, group them by comparability, determine if you're paying employees within those groups differently for comparable work, and if you are, whether an exception applies that permits that variation. So you're probably asking, why should I do this? It sounds like a lot of work. And you're right, it definitely is a lot of work, particularly for large employers, but there's a lot of incentive to complete one of these self-evaluations. In particular, the new law gives an employer who has conducted a self-evaluation an affirmative defense to a pay discrimination claim if the self-evaluation was conducted within 3 years of the claim being made, and the employer can demonstrate that it's made reasonable progress towards eliminating any pay disparities that were identified by the evaluation. And not only does it give the employer a defense to an Equal Pay Act claim under this new law, it also gives the employer a defense to pay discrimination claims made under the Massachusetts General Anti-Discrimination Statute, Chapter 151B. Using the self-evaluation as a defense is important because there's a high risk associated with a pay discrimination claim. In particular, double damages. So if an employee prevails on an Equal Pay Act claim, the employer will be liable to that employee for double the amount of unpaid wages plus attorney's costs and fees. So being able to invoke the self-evaluation affirmative defense is really important. But in order to successfully take advantage of this defense, the evaluation must meet certain standards. It first must have been completed in good faith, meaning that it wasn't completed to achieve predetermined results or to justify known disparities. It also has to have been reasonable in detail and scope. Now so what's reasonable in detail and scope really will vary depending on the size and complexity of an employer's workforce, but factors that will be considered in determining whether it was reasonable include things like the number of employees, how much information was reasonably available, and how sophisticated the analysis was within the evaluation. And then finally, in order to take advantage of this defense, the employer also has to demonstrate that it's made reasonable progress towards eliminating pay disparities that the self-evaluation revealed. But this demonstration is required, so it's important that you document each and every step that you're doing to eliminate these pay disparities. And it's important that you take these remedial steps as soon as possible and definitely no later than 6 months after the completion of the self-evaluation. Finally, you should consider working with an attorney to conduct these evaluations so you can bring the results of the evaluation within the scope of attorney-client privilege. While in most circumstances, the fact that you completed an evaluation and the results of the evaluation are not admissible to be used against you in one of these claims, but that's only for Equal Pay Act or Chapter 151B claims. That does not mean that the results can't be used against you in other types of claims, like a federal discrimination claim. So working with an attorney to complete it and protecting it by attorney-client privilege is important so you keep the option of keeping it confidential available. All right, I know I just threw a lot of information at you. I'm sure you have questions. So I'll start taking those questions at this point. But while you're thinking about those questions, I thought I'd leave this summary chart on the screen just to refresh your memory about what we've covered today. All right, we've got a few questions so far. Let me just read them. So one of the questions is about that. I think it's asking about that supply and the fact that supply and demand is not one of the exceptions. The question is, I would like to confirm that when hiring new faculty that are paid based on years of prior experience and educational background, we cannot place a hard to fill position candidate higher on the pay scale, even though we have more money to pay these hard to fill faculty spots. So that is true. If the position requires a greater degree of experience, then you can pay that person more, but you can't pay someone more simply because the position is harder to fill. So if it's harder to fill math and science teacher positions than it is to fill history and English positions, but all of the positions require the same level of experience, you have to put them on the same pay scale or in the same place on the pay scale. So someone else just asked if there have been any court cases since this new law went into effect, and that's a really good question. There was one case that was filed the day after the law took effect. You probably read about it in the Globe. It was that Boston Symphony Orchestra case where the female lead flutist was claiming that she was paid less than the male lead oboist. And I was really hopeful that by the time this webinar occurred, we'd have a little bit of guidance from the court that would give us a little insight into how the court is interpreting this new law. But unfortunately, the case settled, so we will not be getting that guidance. Although I do expect, like I said, I expect this new law to see a lot more enforcement activity than the prior versions of the law did. So I do expect court guidance eventually, hopefully soon. So someone else just asked if we could help them come up with job description templates and give them feedback on their existing clients. We're happy to do that for anybody who wants us to do that. We can also help you review your applications to make sure they're compliant, your interview materials, and things to that effect. Feel free to, my contact information will be at the end of this, and feel free to call me or email me to ask for that. So the next question is a really good question. Somebody asked if we can fix the supply and demand problem by making sure to hire women into higher paid positions. And unfortunately, no. So here's it. So the old law, before 1980, the law said you can't pay women less than men. And then in 1980, it was made gender neutral and just said you can't pay somebody an employee in one position differently than an employee in another position based on gender. So it made it gender neutral, and the new law kept it gender neutral. So you can't pay women more than you pay men if they're performing comparable work. All right. Another question about teachers. So in terms of the math science teacher example, what if the position as a math science teacher required more teaching time than a history teacher? Is it okay with having salary differences there? I think yes. I think I would need to know a little bit more facts behind this one to really give you a good analysis. But my initial reaction is you might be able to use the quality or quantity of production exception. If they're required to work more, you could probably pay them more. But again, that's something where more facts would be helpful. So this is another good question. How does market data show that one type of role is valued more in the market than that of another comparable job? I think this brings us back to the supply and demand problem. So just because if one role is valued more in the market than a comparable job, you have to pay them both at the same high value. That said, if one is valued significantly more, it may be that it's not actually comparable to that other job. So we would need to kind of conduct a fact-specific analysis about the two separate jobs and see if if they're one comparable, and if they are, if there's an exception that would apply. So the next question is salary market data irrelevant? Jobs in the same grouping may show differing market rates. Essentially, yes, the salary market data is irrelevant. The going rate for a position is irrelevant if the going rate for a position performing comparable work is lower. I got another question here. Is this only meant for large companies? We're small, we don't really have people performing similar jobs. Really good question. The law does apply to all employers equally, regardless of the number of employees one has. That said, I think the way it plays out in real life is going to be different for large companies than it's going to be for small companies. Small companies probably have fewer positions performing comparable work, whereas larger companies, since they have so many more employees, there are probably more that would fall into those comparable work groupings. All right, I have one last question here. Oh, nope, got another one too. All right, I'll do this one first. So somebody asked if there were any job categories that were exempt from this law, and the answer to that is no. I think what you're thinking of is the Fair Labor Standards Act dichotomy between exempt and non-exempt employees. There is no concept like that in this Equal Pay Act law. Regardless, there's no category of employee that is not subject to this. One more question. I'm just reading through it quickly. Can I pay two different jobs, two different comparable jobs, different wages, if there are equal numbers of women and men within each job, and within each job, men and women are paid the same? That's a good question. It's a tricky one. I think my initial reaction is no, because if the jobs are really comparable, then the men, even though some women are being paid the same as men, the women in the other types of comparable jobs would not be being paid the same as those other men in those jobs, so you'd have to pay them all the same. That's, again, though, that said, we might be able, I mean, there might be a creative way to, you know, really dig into the comparability analysis or determine if exceptions apply. So looking at facts there would be great. All right, so as you can see, it's a really complex issue. It requires a really deep analysis into each of the positions, and you know, there are so many nuances to each position that it's hard to answer questions very generically. But feel free to, you know, if you have specific questions, I'm around. You can give me a call, shoot me an email. I'm happy to help. My contact information should be on the screen now. Hold on, small technical difficulty. I think it's on the screen now. It's on the screen now, I've confirmed. So before I let you guys go, I just want to thank you again for taking the time out of your day to tune in. Just again, so you know, we will be posting these slides and a recording of the webinar on our website in the next coming weeks. You'll get an email that notifying you when the materials are available. And again, you know, if you have any questions that I didn't answer today, or you want a deeper answer on, or just want to talk through a specific situations, or if you want help conducting self-evaluations, don't hesitate to reach out. Confirm that my contact information is up on the screen. So give me a call if you need anything. Thank you, everyone.